welcome. It's 10 o'clock. Thank you all for joining me. My name is Lindsay Thomas, and I am one of the attorneys with the Ettinger Law firm. I will be your speaker today. In your browser, you should be able to find a Q&A button. If you do have any questions, I will answer them at the end. I also did receive some questions ahead of time, so we will go over all of those at the end. So throughout, if you think of something, just jot it down so you don't forget it for later. Today, we are going to be going over the 4 advantages of using a trust. First and foremost, we are an elder law estate planning law firm. A lot of people have heard of this, but they don't necessarily know what that means. So an elder law firm is a firm that handles disability planning, so lifetime planning. A lot of people go to attorneys to deal with what happens after you pass away and don't necessarily hit the point of what happens if you're no longer competent while you are alive and can't handle your own affairs anymore. So that is the elder law component of what we do, and we will absolutely be getting into that today. The other component of what we do is estate planning. Estate planning is planning for after you have passed away. So today we're going to be going over how those two things work together, really. A lot of what the planning we do is avoiding guardianship proceedings. Obviously, that's a lifetime plan, saving time and money after you pass away. That's planning for after your death. Keeping assets in your bloodline, that's really planning for your children and making sure that the assets are still there and protected for them if you're no longer with us. Protecting your home from long-term care costs, so we'll go over how we manage that, and keeping control in your family and out of the court system. A lot of what we do in our firm is trying to avoid courts being involved in your family and family matters. So we are going to start with the first reason that we do, trusts over wills. So a trust is a plan, like I said, for while you are alive, as opposed to a will, which is a plan only after you pass away. When you create a will, you name an executor. That person is not actually appointed as your executor until the courts give them the ability to do so. So again, we're trying to make sure that you are taken care of while you are alive. A trust is a lifetime document that provides for basically you to be able to name the person that you would want to handle things for you if you couldn't anymore. They are plans for, again, while you're alive, so while you're healthy. Also, if you're no longer healthy and not able to handle your affairs, a trustee is appointed who could step in automatically to handle your affairs without court involvement. And it is also a plan for after you have passed away. So that's where the two components, elder law and estate planning, come in. A trust really handles both of those. After you pass away, instead of a will saying what happens to your assets, now a trust does so. A will, again, is only for after you pass away and does not keep your family from having to go to court in case you are no longer able to handle your affairs. If you have nothing else in place, New York State has a plan for you. This is called a guardianship proceeding. So as I mentioned before, a lot of what we do is trying to keep you and your family out of the court system. So a trust is the plan that really overrides a power of attorney. It's stronger than a power of attorney, and courts are not allowed to override your trust. So again, it's an even stronger than a power of stronger document than a power of attorney. So we will get into the power of attorney because it's also a very important document, especially if you're not in the stage of life where you need or think you need a trust. So we will come back to the power of attorney as well. The reason we want to keep things out of court as well is because once a guardian is appointed to you, as opposed to you naming the person that you want, the courts can choose a legal guardian. That could be an attorney, someone who doesn't know you, doesn't know your family, doesn't know your wishes to protect assets. They have very limited power to protect your assets. They have to use your assets for your benefit. And a lot of what we're doing is long-term care planning to make sure that we can protect your assets in case you ever do need long-term care. So again, we want to keep things out of guardianship and have you appoint the person that you want to handle those things. Also, this is again where you're naming that person. So it's really trying to avoid conflicts within the family so they know what your wishes are and who you wanted to handle those things for you. Okay. The other thing, as it says here on our screen, is that guardianship proceedings can be expensive and time consuming. That's really true of any court proceeding, unfortunately. Anytime anything goes through the court process, you're probably going to have to hire an attorney, and the courts are not quick. So a lot of times this becomes very anxiety ridden for your family because things need to be taken care of right now, not later on, not when the courts think things need to be taken care of. If you're no longer capable to handle your own affairs, there's immediacy. So again, by having a trust in place, the person who you've named can automatically step in to handle those things for you. Another benefit of a trust is that, excuse me, while you are alive, if you regain the ability to handle your own affairs, you can automatically step back into the role as trustee. So if you had a period of disability where you weren't able to handle things, your trustee could handle things during that period. If you become capable again, you don't have to prove to anyone you're capable. You can immediately step back in to handle your affairs again, as opposed to if there was a guardianship proceeding where you actually have to go to the court, petition the court, and prove to them that you are capable again. So again, super important to keep things out of the court. And I actually think that is our next slide. Yes, I already went over all of that. All right. So I did mention that we were going to be getting to the elder law power of attorney. And of course, I don't know how to go back. So, there we go. So the elder law power of attorney is a really important document. As I said, a trust is a more powerful document, but a power of attorney is super important. The power of attorney is the document that would handle any assets outside of a trust. A lot of times we're not putting everything into a trust, and we'll come back to that. So like checking accounts, savings accounts that are not in a trust, you have to appoint an agent, someone who you trust to write checks for you, pay bills for you, if you no longer have the ability to do so for yourself. It is also a very important document between spouses. A lot of people don't realize that your spouse does not have automatic authority to handle things for you if you haven't given them that ability. Most people have certain assets that, even if everything else is joint, certain assets won't be joint. Things like retirement accounts. And it's not because you don't want your spouse on them, it's because they cannot be joint. IRAs, 401ks, 403bs, deferred comps, TDAs, TSPs, anything that would be considered a retirement account. Your spouse may be the primary beneficiary of those accounts, but they are not joint owners, which means if you are alive and no longer able to handle your own affairs, your spouse does not have the ability to make the phone call to the company that holds your retirement account and speak to them. You have to have given them a power of attorney. You have to have named them as your agent. Also, we want to do this for things like life insurance policies. While a life insurance policy can be a joint policy, most of them are not. They're usually individually owned with a spouse as a beneficiary. So even for those types of things, non-retirement annuities are usually individually owned. So again, there are many reasons that even between spouses, this is a super important document. Another reason is actually for long-term care planning purposes. A power of attorney has a piece that allows for unlimited gifting. Basically, if one or both of you need care At the same time, New York says that we can actually protect some of your assets even on the nursing home doorstep, as long as you have granted someone the authority to make gifts through your power of attorney. So power of attorney is also very important for protecting assets. A lot of people don't realize that. If you get the online version of a power of attorney, it exists, it's out there, that won't give you the option to do the gifting, because that has to be done in what's called a modifications portion, and the modifications don't exist on your basic power of attorney that you can find online. So that's something that an elder law attorney would help you with. Okay. We are going to move on to reason number 2 that we prefer trusts over wills. So the second reason that we prefer trusts over wills is that wills do not protect your assets from what we call a probate proceeding. So a lot of people know your will is where you name your executor, but they do not know that your executor cannot automatically step in to handle your affairs after you pass away. Your executor actually has to petition the surrogate's court and ask for permission to be your executor. In doing so, they also have to get permission from any of your next heirs at law. And New York State says who your next heirs at law are. If you are married with no children, your next heir at law is your spouse. If you are married and have children, it is your spouse and your children. If you are not married and have children, it is your children. And then it can go out to siblings. It can go up to parents. If you don't have siblings, it can go out to cousins, aunts, and uncles. So a lot of people want to make sure that their family members do not have to be involved. So a lot of times we are using a trust to avoid that court process. You may have heard of people contesting a will. That is because they are given the opportunity to do so. Any next heirs at law have to sign a waiver and consent allowing the will to be probated. And if they don't sign, basically automatically goes through a court proceeding, which again can be costly and time consuming. A will is also a public record. Once a will gets filed with the surrogate's court, anyone can view your will. A trust is a private document. Only the trustees and the beneficiaries of the trust can ever see the contents of the trust. So again, big advantages of doing a trust over a will. A trust also saves a lot of time after you pass away. I'll often tell my clients to think of a trust as a box. We're essentially moving assets from outside of the box and putting them into the box. So after you pass away, instead of the court's ruling what happens to those assets, your box does. Your box being the trust. So your trust says what happens to those assets after you pass away. It avoids the probate process. That means that your family members, your next heirs at law, do not have to sign off on anything, which of course saves your family time and money. And as we already mentioned, trusts are private documents. Your trustee can step in immediately to handle your affairs when you pass away, again, without having to ask for court permission. So that is ideal. Trusts are much harder to contest, again, because your beneficiaries, your heirs, do not have to sign waivers and consents. The trustee automatically steps in. They don't have to be appointed after you have passed away. If you have property in multiple states, you have what's called a multiple probate problem. If you only have a will, your will must be probated in each state where you own real estate. So if you have property in New York State and you also have property in Florida, your will must be probated in New York and also in Florida. Most attorneys are not duly licensed, which means your family will have to hire an attorney here and in Florida. By creating a trust, you can put both of your properties into that trust. And when you pass away, your trustee does not have to ask for court permission in either state. So if you have property in multiple states, a trust is a very good tool to avoid that multi-probate problem. Number 3 reason that we prefer trusts over wills is actually for protections for your children. After you have passed away, a lot of people are concerned about what happens to those assets. Do they go to the child's spouse? Do they go to the grandchildren where people typically want them to go? If your child does not have your grandchildren, would it go to their spouse, or would it go back to their siblings? There are ways, there is a tool that you can use to make sure that those assets stay with your family and don't go to your children's potential spouses. It is what we call an inheritance protection trust. It is also known as a bloodline trust. The purpose of an inheritance protection trust is really to make sure that when you pass away, the assets from your box, remember we talked about as a box before, the assets that you put in your box now transfer into your children's boxes. So we are now creating a trust for your child Jane and your child Joe. So they have boxes that are funded after you or you and your spouse have passed away. While you are alive, nothing goes into the Jane and Joe trust. They are unfunded boxes waiting for inheritance. After you pass away, your trustee distributes the assets into those 2 boxes, and Jane and Joe become their own trustees. However, those assets never touch Jane and Joe as individuals, which means they are divorce-proof, lawsuit-proof, and creditor-proof boxes, if you will. So if something happens in their marriage, those assets are not part of the divorce process. If your child passes away, that is not part of their estate planning that may say it goes to the spouse. That's where the bloodline piece comes in. Those trusts typically say that if your children have children, so your grandchildren, those assets would go down to your grandchildren. If they do not have children, they would go back to your surviving children. And if you only have one child, of course, you can name where those assets go if something happens to your child if you don't have grandchildren. So you get to decide where those assets go instead of your child's estate planning doing so. All right. A lot of people are concerned also that if their child passes away and assets go to the spouse of that child, the child's spouse could get remarried and those assets could end up with a stranger or a stranger's family. These child's boxes, the Jane and Joe box, really keep it from going in that direction and keep it with your family members, or even potentially, charities, if that's what you choose to do. If you don't have any grandchildren, you get to decide. We already went over this. After you have passed away, any of the assets in your child's trust now go down to your grandchildren. They go by blood. If your child doesn't have children, I already mentioned, it would go back to their siblings' inheritance protection trust. If you choose to do so, you can leave assets to a son-in-law, daughter-in-law. In fact, my parents did that for my brother-in-law. We love him. They've been married for 25 years. So they did leave a little bit to my brother-in-law, but most of it is going to my nieces. So there are provisions that you can put if you choose to do so. But of course, that's personal to you. Okay. This also makes sure that you can plan for after you have passed away. A lot of people think that, once they die, that's it. They don't have any say in what happens to the assets. Those inheritance protection trusts make sure that you do still have a say in what happens. The next reason that we do trusts over wills is actually one of the big reasons, the reason a lot of people do planning. It's to protect assets in case, heaven forbid, they ever need long-term care. And we don't want our clients to need care, but if they do, we want to make sure that their assets have been protected. And when we do this, we do what's called a Medicaid Asset Protection Trust, Medicaid Asset Protection Trust. It is also known as an irrevocable trust, but it's not really irrevocable in New York. That's a misnomer. In New York, let's say we did an irrevocable trust. The disadvantages we'll actually start with, usually go over the advantages first. We'll start with the disadvantages. The disadvantages are that you can't be your own trustee and you don't have access to the principal of the trust. However, even though it's called an irrevocable trust, you can't be your own trustee, you can fire the trustee without their permission. So a lot of times, again, I also think of it as a corporation. You are the CEO, your trustee is the manager. If the manager does something that you don't approve of, you can remove them as the manager of your trust without their permission. You are still the boss. You can also change who the beneficiaries of the trust are. So again, the name irrevocable makes it sound like you cannot make changes. That's not true in New York specifically. And I want to be very clear, if you have friends living in New Jersey or in any other state, these laws do not apply to them. These are all New York State specific laws. So keep that in mind. If you intend to move to another state, these laws will not apply. New York State specific. So in New York, the purpose of a Medicaid asset protection trust and irrevocable trust is twofold. It both starts the 5-year clock on any assets that we transfer in. So after 5 years of those assets being in the box, they cannot be looked at as available resources for your care. The other benefit of an irrevocable trust is that it does avoid probate also. So with a revocable trust, you avoid probate only. That's the only benefit of the trust. You are your own trustee. You have complete control of the assets in the trust, only avoids probate. It never protects the assets in case of a long-term care situation. With this Medicaid asset protection trust, you are both starting the 5-year clock and avoiding probate on the assets that you transfer in. The main issues here are, again, that you cannot access the principal of the trust, which usually isn't even that big of a deal because we only transfer in those assets that you do not spend. Things like your home. You don't spend your home. You live in your home. I have clients who have CDs that they've been letting roll over for years and years and years. If you do not intend to touch the principal of those assets, let's get them protected so that the government can't touch them, a facility can't touch them. These are income trusts. If you have investments or CDs in the trust, you are still entitled to any income, interest, or dividends that the trust produces. So you'll still be receiving your income. We also never transfer in like your basic checking and savings accounts. I want you to have enough money that you can still live your life. The goal is to protect assets, but it's to make sure that you are still living the same way that you were before you did the trust. So your checking and savings accounts remain outside of the trust. We add beneficiaries to those accounts to avoid probate on them. But again, we don't want to necessarily put them in the trust because it changes account numbers. And a lot of people have a lot of direct deposits, direct debits, and also you want to still have control of your finances. We never put retirement accounts into a trust, IRAs, 401ks, 403bs, deferred comps, TDAs, TSPs, because they are already by law protected. If you need care in a facility in New York, they cannot look at the principal of a retirement account as an available resource for your care. They can only look at the required minimum distribution that you have to currently start taking at 73. That distribution is income, and unfortunately, there is no way to protect income. So these are asset protections, not income protections. The 5-year look-back period is what we discuss for facility care. If you need in-home care, there is a program in New York called Community Medicaid, where you can actually get care providers to come into your home if you financially qualify. Currently, there isn't a look-back period. So nursing home care is a 5-year look-back period. In-home care does not have a look-back period. However, they passed a law back in 2019 saying that there would be a 2.5-year look-back period for in-home care. So that can actually change at any time. So they may change it to a 2.5-year look-back period, but currently there is no look-back. With a Medicaid trust, one of the concerns is often, do I still get my STAR benefit? Can I sell the property in the trust? Yes. If you get enhanced star or any star, you are still entitled to that because you still have exclusive use and enjoyment of the property. If you sell your primary residence, you still get your $250,000 capital gains exemption. So you are not losing any of those things. If you sell a secondary property, I mean, you still get the capital gains tax because it is a secondary property. That doesn't go away, but you can still tell your trustee to sell it, and they have to do so. And if they don't, you fire them, you remove them as your trustee. So you are still in charge of this. So in conclusion, and I am going to be taking questions soon, as soon as we go over this, the purpose of the trust is to avoid a guardianship proceeding, keep assets and, your finances and everything out of the court process. After you pass away, you are keeping that within your family as well, instead of the courts getting involved and appointing your executor, even though you've already named them, they still have to be appointed. Protecting your assets for your children and their divorces, lawsuits, creditors, making sure the assets stay within your family. Also protecting assets in case there is, heaven forbid, a long-term care situation. The way our firm works is different than other firms. We do, of course, this seminar first. Then we do an initial consultation. It is a complimentary consultation. And I want to be very frank, everybody is different. There is no one size fits all answer. So that initial consultation is really where we're getting to know each other. You're asking me questions, making sure that I know what I'm talking about. I'm giving you, advice or options, because again, there's no apples to oranges when we're doing estate planning. You can't say, oh, my neighbor did this. We have to look at your set of circumstances and see what would work for you and your family. So it really is personalized to you. So at that first meeting, we're really going over concepts, going over what it is that we think you should do. Then, if you bring any of your previous documents that you already have existing, we can review those for you at that meeting. We can look over those together. I will let you know exactly what I believe needs to be updated in those, if anything. Sometimes the answer is no, these look good. You don't need to update anything. That's okay too. When you leave your first meeting, I will be giving you a copy of the book. I believe you can see that on your screen. That is the Ettinger Law Firm's Guide to Protecting Your Future. I will give you a copy of that. And based off of our conversation, I will write down specific chapters for you to read. The book is very easy to read. It's not in legalese, so it is a really good resource because we're going over a lot of information. So it's important that you understand what you're doing, that the reading material definitely helps reinforce what we talked about during our first meeting. At that first meeting, we will go over fees because again, everybody is apples to oranges. We do everything flat fee. However, I don't know what I need to do for you until we have that initial meeting. So before you leave, you will know exactly what it would cost to do the plan that we are talking about. After the first meeting, we do a second complimentary consultation where we go over any additional questions that you have. A lot of people use the book as a resource. They will highlight, they'll come back in with multiple questions based off of their reading. And, you pick my brain at that point. We'll go over anything that you came up with or, the things that you forgot to ask during the first meeting. So again, we do have that second meeting. After the second meeting, we go over, if you decide that you want to move forward, we will draft your estate plan. You will tell me who you want to handle things, who you want as your trustee, your agent on your power of attorney. So we will work together to make sure that the documents fit your needs. At the second meeting, we will also actually give you a physical proposal. So you will have it in writing. So the fees are not going to change. That is exactly what they are. We do not charge for things like telephone calls or emails. There are no annual fees or maintenance fees. We don't do retainers, which means that if you changed your mind after the second meeting, even if we've gone over the drafting, if you change your mind, you're not actually paying us anything because we don't take any payments until the day that you sign. So even if we've drafted everything and you change your mind, we're still not taking any payment for you. That's really a lot of peace of mind. So that if you decided not to, we don't have any of your money. So that's good for people. We can take credit card payments. We can also also take checks. So there are different options on how to pay us. But again, nothing is due until you actually sign documents. When you become our client, you become our client for life. This is very different than other firms because we don't do any sort of billable hours. If you have questions, if you need us to, you're selling your house and you need us to email documents to your real estate attorneys, we don't charge for any of that. You can call us and we can get those documents out to whomever we need to get them to. Whenever something major changes in your life, we actually ask you to come back in so we can discuss how that affects your planning. And if there are no life changes, no major life changes, we still ask you to come back in for a complimentary review every 3 years. So again, in the event of major life changes, or we've just hit that 3-year mark, it's a good idea to do a review because a lot of times people do their planning and then they forget what they've done because this isn't what you do every day. I do it every day. You don't do it every day. And I understand that. So we can go back over what you did, why we did it. And sometimes people want their children to be involved as they get older, so they also understand the process. Some people don't want their children involved at all. Some people want their children involved in the whole process, and that's based off of you, what your expectations are. So we work with what you want for your plan. We already went over this. There is no phone call for, I'm sorry, no charge for telephone calls or emails, asking questions. Anytime you send us emails, we will get back to you either by email or call. To get started, we ask that you give us a call or visit our website. You can see that right here. Our website is ettingerplan.com. And you can schedule a free consultation there, or you can call our number. It is 1-800-500-2525, or trustlaw.com. So ettingerplan.com or trustlaw.com, that'll be getting you to the same exact website. We just have 2 different domains for that. ettingerplan.com, trustlaw.com. If you would like to come in for a consultation, again, call us at any time. We can set that up for you. I'm going to end the, there we go. I'm going to end that portion of our meeting and I will start to go over questions. First, I'm going to address any questions that were sent ahead of time. And let's see. Catherine asked, we are interested in learning about protecting assets using a trust, and also interested in learning about elder care insurance options. Elder care insurance options, I would really defer to an insurance provider. They will have the best recommendations for that. If you do need a recommendation for that, we can go over that at a first consultation where I can give you a direct reference depending on where you live. As far as protecting assets, that would really be with that power of attorney. I talked about how we can save assets on the nursing home doorstep where we do what's called a gift and loan strategy. If you have money and you go into a facility, we want to make sure that some of those assets are protected. We can save approximately half of the value of your assets, even on the nursing home doorstep, with what we call a gift and loan strategy. But your power of attorney has to allow for that. So that is super important. So we do the power of attorney. We also use the Medicaid Asset Protection Trust to protect assets in case of a long-term care situation. That is that irrevocable trust that we talked about. So, when we do the consultation, we can talk about what goes in, what stays out, and your specific circumstances. I need to set up a trust, but I need to learn about the procedure to do so. Carol, to set up the trust, again, we do that first meeting where we go over making sure that it even makes sense to do a trust. And sometimes people already have documents in place. Sometimes people don't have assets that they need a trust for. So we will go over what you actually need at that first meeting. Then we give you the book, whether it's a trust or not, we'll still give you the book to read over your options. At the second meeting, you would give me the information that I need to actually create the trust document. And usually after the second meeting, it's about a 2 or 3 week window from second meeting to actually signing documents. It's not usually months, unless you want it to be months. It's usually a couple of weeks that we need in order to draft those documents and get everything scheduled. Thank you for the free webinar, no problem. Does the law firm assist in coordinating decedent's financial assets with client's financial advisor. So decedent means someone that has passed away. So if someone has passed away, yes, we can work with financial advisors, but also if we're funding a trust while someone is alive, so that we don't have to go through probate, we are often working with financial advisors to do that, to make sure that everything is funded properly. And improperly funded trust is not doing you or your family a whole lot of good, because the goal is to stay out of court. If we haven't funded it properly, you're not staying out of court. So it's our job to really work to make sure that happens. That's also the reason for the 3-year review. Every 3 years, we're making sure, hey, did you open new accounts? Are they beneficiary designated? Did you sell, buy anything that we need to know about that could affect the plan? So we're really reviewing these things to make sure that the plan works for the rest of your life and after you have passed away. Yes, so yes, we do that. Do we more trust? Do we need a trust for our estate? That's not something that I can answer until we actually meet in person. Some people do, some people don't, and that's something that I will discuss with you. Again, sometimes the answer is no, you don't need a trust, or no, not yet. Sometimes you don't need a trust until, you're a little bit older. Sometimes people are moving out of state in the next couple of months, and I say, hey, hold off. If you're going to be moving to, I don't know, North Carolina in 6 months, wait to do your planning until you get there, because you're going to be paying us and then you're going to be paying the attorney there. So sometimes that's the answer also. That's just very dependent on you. Okay, so those were the questions that were sent ahead of time. I'm going to get into the Q&A. What happened to transcripts button on the bottom? That I don't know. I don't know anything about the technology in here. I'm very sorry about that. I will ask my monitor, but I believe she will be sending out a recording of this after we are done. Do you need a living trust to establish an inheritance protection trust? No, you technically don't. An inheritance protection trust can be used without a living trust. You can use it when we have a will. A will can lead to an inheritance protection trust, but the will would still be governed by the courts. So the executor would still have to be appointed by the court in order to get the assets to the inheritance trust. Or an inheritance protection trust can also be used for things like retirement accounts. When you leave assets to a spouse, your spouse has the benefit of taking assets over their life expectancy. Your children don't. They have to take them out within 10 years of you passing. A lot of people want to make sure, because their retirement accounts are a lot of times their largest assets. If you leave those retirement accounts to the inheritance protection trust directly, it wouldn't go through the will. There are no negative tax implications the same way that there are if we leave them to a family trust. So yes, you can create an inheritance protection trust. It can be a tool for retirement accounts, can also be left to through a will. But again, we would go over whether or not that makes sense for your family. Thoughts on a trust versus a FLP for a small business owner operating entity with significant real estate holdings as well? Also, if your homes still have mortgages on them, can they be put into a trust? So on the first piece, whether or not you're doing a family limited partnership for businesses or you're doing a trust, sometimes the partnership does make more sense because it has more protections. When you're doing a revocable trust, it doesn't have any of the lawsuit protections that, partnerships do. So that might be something that you want to look into with someone who actually does family limited partnerships. We don't do those. So sometimes you do them together. You can do a trust and a limited partnership because you might have holdings that aren't in the small business. So again, that's very specific, and we could go over that, during a first meeting. Real estate holdings, whether they are already owned by a corporation or an LLC, or if they are individually owned, that matters. If they're individually owned, we can put those into a trust. But again, there are no lawsuit protections. You still have to keep your homeowner's insurance on those properties. If they are already owned by a corporation or an LLC, we can assign the ownership interest to the trust, or there are different ways to, have businesses and have a trust at the same time. Also, if your home still has mortgages on them, can you put them in a trust? Yes, you can. So basically, there is this law that says that mortgages cannot be called if you transfer property into a trust. However, the trust have to fall under the stipulations of that law. It's called Garn St. Germain. And the trusts that we create do, whether it's a revocable or an irrevocable trust. Sometimes we have had to have banks review them to make sure that it abides, and it does. So yes, you can absolutely do that. Sometimes with a revocable trust, people, do or don't notify their mortgage company. That's up to you. With irrevocable trust, a lot of times they want to know more often than other times. Does anyone have any more questions? I think we went through everything that I had here. Let's see. I don't see anything else. Oh, thank you. Thank you, Bob. No problem. But again, definitely we can set up that complimentary consultation whenever you're ready. We can do that here. And I work, oh, this is important. I work in our Fishkill office. I work in our Middletown office, and I work in our New City office. So if any of those 3 offices work for you, you can absolutely meet with me or any of the other attorneys that are here. If you like my presentation, you wanted to meet with me, just call and say, hey, I'd like to meet with Lindsay. That's absolutely fine. If you'd like another attorney, that's absolutely fine also. Thank you so much for joining me today. And I am going to just check one more time, make sure there's nothing there. Nope, nothing else. So I'm going to end our presentation. Thank you again so much for joining us.